Sir, go ahead. Sir, go ahead.
ఈ ఫ్యాన్ ఉంది సార్.
Sir, go ahead.
Relax, sit there, sit back.
No problem. No, ఉండని.
సార్ ల్యాప్టాప్ ఉంది అందుకని మీకు సిట్ బ్యాక్.
Easy, sir.
నేను
ఉండని. See, today, good evening to all of you. Today we'll discuss about the pleadings as far as the Rent Control Act is concerned. Though the Rent Control Act has become obsolete now because of the rents being fixed, that is to say that all premises below the figure of 3,500 as far as municipal area is concerned, and 2,000 as far as non-municipal area is concerned, and 15 years from the date of construction, it is you have to come only from the through the Rent Control Code, that is under the AP Buildings Lease Rent Eviction Control Act 1960. As far as the pleadings in rent control matters are concerned, you say in the court of the principal rent controller, Secunderabad or Hyderabad, as the case may be, and all matters under the rent control side is numbered as RC, that is rent control case, or RCC. They call it in Karnataka and Tamil Nadu, but here we call it as RC, and number of whichever year it is. Then you give the name, address, and description of the petitioner and the respondent, and then you say petition for eviction and arrears of rent under section 10, whatever clause is there, whether please remember the clauses for eviction is default, subletting, additional accommodation, self-occupation for residence, self-occupation for business, additional accommodation, then acts of waste, acts of nuisance, or the tenant has secured alternate accommodation or has ceased to occupy the premises for a continuous period of 4 months. All these grounds are there under section 10 of the Rent Control Act. The first thing is the petitioner above name begs to state as follows. Then name, address, and description of the petitioner, name, address, and description of the respondent. Then after that, you say address for service and address for service. And the next one is brief facts of the case. You say that the petitioner is the landlord and owner of premises number so-and-so situated at so-and-so. And the respondent, here in all rent control matters, you call the parties as petitioner and respondent respectively. The petitioner is the absolute owner and possessor of house number so-and-so, situated at so-and-so place, and by virtue of having purchased the same from so-and-so through a registered sale deed bearing document number so-and-so. A copy of the sale deed is filed herewith and marked 1. Next para is that the respondent is a tenant of the petitioner in respect of the petition scheduled property on a monthly rent of rupees so-and-so under the terms and conditions of the rental agreement dated so-and-so, and the tenancy is from month to month, and the rent for every month is payable on or before 5th of every English calendar month, and the tenancy month is from the 5th to the 4th of every English calendar month, and the copy of the rental agreement is filed herewith and marked so-and-so. Next para is the respondent is highly irregular in payment of rents and owes the petitioner a sum of rupees so-and-so towards arrears of rent from so-and-so to so-and-so, and in spite of several demands and requests, the respondent has not paid the rents and hence is a willful defaulter in payment of rents. Then next para is that the respondent has also sublet the premises without the written consent of the landlord, written consent of the petitioner, and therefore has violated the terms of tenancy and is liable to vacate on that count. Then next para is you say the respondent has ceased to occupy the premises for a continuous period of 4 months and has secured alternate accommodation and is not in occupation of the petition scheduled property and therefore liable to vacate on that count. Then as many grounds as you like, sir. The petitioner is residing in a rented house and paying rents, and due to health problems, he is advised by his doctor to stay in the ground floor, and therefore the petitioner requested the respondent to vacate and deliver possession, but the respondent has not vacated till this date, and hence the respondent is liable to vacate on the ground of self-occupation as far as the petition is concerned. Next para you say is the petitioner called upon the respondent to pay the arrears of rent aggregating to so-and-so through his legal notice, and the respondent received the notice but did not send any reply nor paid the rent. Then after that, next paragraph will be cause of action for the petition arose on so and so date when the respondent defaulted in payment of rent and ceased to occupy the tenanted premises, and also on subsequent dates when the petitioner, through his legal notice, called upon the respondent to vacate and deliver vacant possession, which he has not done so. Next para is this honorable court has jurisdiction to try this petition as the petition scheduled property is located at Regimental Bazaar, Secunderabad, within the jurisdiction of this court. And next para is a court fee of rupees 2 is paid under section 10, I'm sorry, under schedule 1, schedule 2, article so and so, article 1K or whatever it is of the Court Fees Act. And the next para is the petitioner submits that he has not filed any prior petition for eviction and no petition is pending before this honorable court. Last para is the petitioner therefore prays that the respondent and all persons holding possession through or under him to vacate and deliver possession of premises number so and so situated at Regimental Bazaar, Secunderabad, and cost of the petition be awarded. Then the petitioner signs and the counsel also signs, and then the verification also is done, and the party says that the facts mentioned before the cause of action paragraph are true and correct, and from cause of action to the prayer clause, he says it is true to the best of his information, which he believes to be true after the contents were read over and explained in Telugu, which he understands, then and hence verified at Secunderabad on this the day of so and so. Then the petitioner signs. Then after that, you file the list of documents, whatever documents you rely upon in support of your claim. You mention it 1, 2, 3, 4, 5, 6, and then the petitioner signs. And below that, please remember this is the most important recital which you have to mention in the eviction petition. That is what is called the schedule of property. You give the schedule of property along with the boundaries, and then the party says the schedule mentioned above is true and correct, and then the party signs, and then you prepare the docket and then file. But if the tenant is in default of payment of rent, then you also file an interlocutory application of what is called an IA under the provisions of Section 11 bracket 1 of the AP Buildings Lease Rent Eviction Control Act 1960. That is, in the form of an affidavit, you say whatever you have stated that he is a defaulter in payment of rent, so on and so forth, and then you say the petitioner, I therefore pray that the petitioner be directed to pay the rents from so and so period to so and so period, and in default of payment, all proceedings be stopped, and I may be put in possession of the property under Section 11(4) of the AP Buildings Lease Rent Eviction Control Act. And the petition which you file is also what is called petition under Section 11 Clause 1 of the AP Buildings Lease Rent Eviction Control Act 1960. It's the same prayer you write there, and the council also signs. This is how an eviction petition is filed. And one more thing you must remember is there is one more provision called fair rent. Fair rent is suppose the tenant is paying a paltry amount towards rent, and the rental values have gone up, taxes have gone up, and then your cost of living also has gone up. Then you say that the neighboring premises with a similar location, similar accommodation can fetch easily a sum of rupees so and so towards fair rent, and therefore you request the court to fix the fair rent as far as the tenanted premises is concerned. This is the rent, as far as the rent control proceedings are concerned, it is the cheapest remedy possible. You pay only 2 rupees, and then you pay the requisite stamps on the wakalat, and also the process for notice to the other side. And also, as far as the IA is concerned, calling upon the tenant to pay the arrears of rent, there also you have fixed only 2 rupees stamp paper, 2 rupees stamp, court fee stamp. And then if there's only one respondent, the copy of the petition, copy of the IA, what you are filing, and there is summons to respondent. It's not settlement of issues. It's called summons to respondent. You fill it up and file it in triplicate so that one goes through court and one goes through registered post. And all the material papers which you file into the court, a copy of it will also have to be provided for the other side. This is how a rent control petition is drafted. Then in the Rent Control Act itself, you have got various remedies open to the tenant also. Suppose, let us say, the landlord refuses to receive the rent sent by money order, then in that case, what the tenant can do is he can address a notice to the landlord, sir, you are not receiving the rent in spite of being sent in money order. Please nominate your bank in which the rents could be deposited, your bank account number. If he does not provide it, then direct the money order commission and then remit the rents. And then after that, if even after that it is not possible, then you file a petition under Section 8 asking the court to permit you to deposit the rents into the court. And under 8, you can always file a petition for deposit of rents. Then Section 9 also is there, which says that in case there is a bona fide doubt or dispute regarding the person entitled to the rent, then you can say, sir, there are two people claiming the rents in respect of the property. I do not know to whom to pay. Please permit me to deposit the rents into court and let the court decide as to who is entitled and let him take the money so that you get yourself absolved of the liability of willful default. Then you have got one more provision called Section 14, Section 12, I'm sorry. This is available to the landlord. Suppose the premises is in a dilapidated condition, requires demolition and reconstruction, then in that case, you can file it under Section 12 and ask the court to pass an order of eviction as far as the tenant is concerned to facilitate demolition and reconstruction. But only one condition is as soon as the premises is reconstructed, you must offer it to the same tenant on the agreed rent, whatever is going to be agreed. Then you have got one more provision called Section 14, which says of amenities. Suppose the water supply is cut off, electricity is cut off, and the tenant is deprived of the amenities of electricity and water. Then in that case, he can file a petition under Section 14, narrate all the facts, and then the court will direct the landlord to provide the necessary amenities as per law. Then there is one more provision called Section 20, which speaks about appeals being filed against the orders of eviction passed by the lower court. Then in that case, you will have to file an appeal under Section 20, narrate all the facts like what you draft a regular appeal, and then file it in the appellate court, whichever is the appellate court, and then agitate that matter there. Then the appellate court is seized of the matter, and along with that, under Section 20, Clause 2, you can also file an interlocutory application to stay the execution of the eviction orders. But one condition is, unless you deposit the rents, whatever is due, you will not get a stay order. So, and Section 22 is also there, where you have got a right. Suppose the appeal goes against you, you've got a right of filing a revision before the High Court under Section 22 of the AP Buildings Lease Rent Eviction Control Act, and then state what are the facts and how you have been misled, how the courts have committed a mistake, and all those points you can raise it in what is called civil revision petition or what is called CRP. Only the High Court is entitled to entertain CRPs. So these are the various provisions under the Rent Control Act. Because of lapse of time, Rent Control Act has become almost obsolete. Please remember those days when we started our practice, right from 10 o'clock to 5 o'clock, we'll be sitting in the rent control court, either appearing for the landlord or the tenant. It was a profitable, what is called litigation, but please remember, don't be enamored. The landlord comes to you, but the tenant pays you more than what the landlord pays because he's interested in safeguarding his possession. But here, as far as non-residential, also you can ask for eviction to say that you do not have a madigi or a shop premises wherein you can carry on business, and you want to intend starting a business in the petition scheduled property, and you want the tenant to vacate on that ground. Then additional accommodation. Suppose your family has grown and your children have grown up, then you can ask the tenant to vacate on the ground of additional accommodation. Only test there is the advantage cost to the landlord should outweigh the hardship cost to the tenant, then only additional accommodation can be allowed. So these are the various provisions under which the rent control petitions are filed. Then we come to the Transfer of Property Act. In the Transfer of Property Act, it is called a contractual lease or a contractual tenancy. Here, please remember, it's almost akin or similar to bailment in the Sale of Goods Act. In the contracts too, there is specific contracts where movable property, here in bailment, movable property is the possession of movable property is delivered by a bailer to a bailee on the consideration for a fixed duration of time on the consideration of payment of higher charges. And Also added to a super added condition that once the purpose is accomplished, the goods will have to be handed over in the same position subject to reasonable wear and tear. So the question of return is there. So the question is, mostly the classic example of that is, suppose you have a function in your house, you require crockery, you require you require a tent to be installed, and then you want chairs, then you want all the other cooking utensils and all. You go to a tent house, order for it, and then get it. You say that you want it for a function for 2 days, but once you and then you have to pay the hire charges also for those goods which you have taken on hire, and then after the function is over, it is your duty to hand over all the goods. So the element of return is there as far as bailment is concerned, and you have to pay the higher charges. That is what the contracts 2 says about bailment. In the same way, as far as immobile property is concerned, it is a possession of. Please remember, the word lease is defined as where the possession of immobile property is delivered by a person called the lessor to a person called the lessee on the consider for a fixed duration of time on the consideration of payment of rent, share of crops, annuities, profits arising out of the business, and the landlord is called the lessor and the tenant is called the lessee. And also subject to a super added condition that once the period comes to an end, the possession of the property has to be redelivered back to the landlord or to the lessor. That's how lease has been defined under Section 105 of the Transfer of Property Act. Now, with that theory in the background, we go into the the pleadings which you prepare in respect of a transfer of property suit. That is, the suit under Section 106 of the Transfer of Property Act. Please remember, most of you have been uh, aware of the labor conditions. That is, it is said you cannot compel an unwilling master to have a servant in employment over which he has lost confidence. And as far as possession of immobile property is concerned, it is not given indefinitely. It is given for a fixed duration of time on the super added condition that the tenant or the lessee has to pay the rents every month. And then after the expiration of the period mentioned in the lease deed, he has to vacate and hand over possession to the landlord. Then the question arises, sir, suppose let us say the lease is given for 11 months. After the 11th month, till 11 months, you can enjoy the property. But once the 11 months period expires, you have no business to stay on stay on in respect of the property. You have to redeliver possession back to the landlord or back to the lessor. But in most cases, what happens is if the lease is coming to an end, let us say the 11th month is coming to an end, the landlord and the tenant agree to renew the lease, and then it is increased by 10% or 6% or 7%. The rent is increased. And such a tenant who remains in respect of the property even after the period mentioned in the document rental deed or the lease deed has expired is called a tenant holding over. Then next one is tenant by sufferance. What do you mean by tenant by sufferance? A person to whom a notice has been given terminating his lease still continues in respect of the property. He becomes a tenant by sufferance and is not entitled to occupy the property. Then he is called a tenant by sufferance. Then you got what is called tenant at will. Please remember you have various festivals in Dasara or the Deepavali. Crackers are sold on the open ground and then it is given for a temporary period, or fruits also, seasonal fruits are there like custard apple plant and so on and so forth. Then in that case, what happens is it is given for let us say 2 months or 3 months, and after that the tenant has to vacate and hand over possession, and he cannot continue to be in occupation of the property beyond that period. So all these things are covered by the Transfer of Property Act. Then how is a lease defined? Lease is defined as where possession of immobile property is delivered by a lessor or the landlord to a person called a lessee or a person called the tenant for a fixed duration of time on the consideration of payment of rent, share of crops, annuities, or profits arising out of a business, and subject to a super added condition that once the period comes to an end, the tenant has to redeliver possession of the property to the landlord or to the lessor. This is the definition of the word lease. And when I come to law of leases, I will discuss everything in detail. So this is the theory part of it as far as the the TP Act is concerned. But of course, going still further, there are three things to say. As far as the tenant at will is concerned, no notice is necessary. Once the period comes to an end, automatically he has to close his shop and hand over possession to the landlord or to the lessor. But as far as the tenant holding over is concerned, notice is absolutely mandatory, that to say that I don't want to continue your tenancy, please vacate and deliver possession. As far as the tenant by sufferance is concerned, the question is the lease comes to an end automatically when you issue a quit notice. These are the three things contained in section 112 and 113 of the Transfer of Property Act. Then we have got two words called termination of lease and determination of lease. Mostly both of them look synonymous, but they are not similar. Why? Because as far as the determination is concerned, determination means once the period for which you have handed over possession comes to an end, the lease gets automatically determined, comes to an end by efflux of time, as it is called. Then, but as far as the tenant holding over is concerned, he continues beyond 11 months. And in case you want him to vacate, then you will have to give a quit notice under section 106, asking him to vacate and hand over possession. So this is all the theory part of it as far as Transfer of Property Act is concerned. And then the question is, there's one more thing called mean profits, MESNE, mean profits. What do you mean by mean profits? Mean profits means MESNE, S is silent, please. Mean profits means, suppose, let us say, the tenant is paying you a rent of 10,000 rupees for a premises, a shop premises or a residential premises. But if the same shop or the same residential premises is let out, the neighboring rents are, let us say, 20,000 rupees or 30,000 rupees, which you can get in case the tenant vacates. Then that amount which you can claim or entitled to claim towards damages and compensation, once you give notice to quit and the tenant still continues in respect of the property, that is what is called mean profits, MESNE, mean profits. Then you've got one more theory part of it to say what are the conditions which apply for determination of lease. That is section 111, what my trademark. That is 111 is, it says how a lease is determined. One is efflux of time, EFFLUX. What do you mean by efflux of time? Efflux of time is if it's given for a fixed duration of time, once the period comes to an end, automatically the lease gets determined. Are you able to follow, please? Next one is merger of interest. What do you mean by merger of interest? Suppose, let us say the tenant purchases your property. Then the relationship of landlord and tenant comes to an end. The tenant becomes the landlord. Then in that case, when merger takes place, then the question of tenancy doesn't continue. Then third one is implied surrender or express surrender. Suppose, let us say the premises is not sufficient for me. I require a bigger premises because my family has grown. That is, I'm talking from the tenant's point of view. He says, sir, I don't want to continue in the property. I'm handing over possession to you. That is what is called by letter. He intimates the landlord or intimates the lessor. That is called express surrender. Implied surrender is he keeps all the doors open, shifts all his samans, no property is left there. It is said, it is deemed that automatically has vacated and then does not occupy the property. Then next one is forfeiture. Forfeiture means where he violates the terms of the lease, terms of the tenancy, he does not pay the rent or does an act which is contrary to the rental agreement or contrary to the lease deed, then the tenant incurs what is called forfeiture. I think in Urdu it is called zabt, raddu jayam. That is called forfeiture. These are all the four clauses which are mentioned for determination of lease. So determination means once the period comes to an end, automatically the lease comes to an end. So the question of no notice is necessary. You can file the suit immediately when the lease expires. But as far as termination is concerned, if the question is issuance of notice is absolutely mandatory. Now we come to the next aspect of theory, that is what is called promissory estoppel. Promissory estoppel, that is contained in section 109 of the Transfer of Property Act. Suppose, let us say, one of you is the landlord, and then let us say you induct me to possession of the property. There's a dispute between you and your brother as far as the property is concerned. As a tenant, if I have been inducted by you, though you may have a defective title, I have been paying rents to you and I have accepted you as my landlord and I have been in occupation of the property, and then it is because of your bounty handing over possession to me. I am in possession. I am not bothered about the disputes between the brothers to say I cannot adopt the policy of a monkey which gets benefited because of two cats fighting for a loaf of bread. Then in that case, what I should do is I must perform my obligations as a tenant and continue to pay the rents to the person, even though he may have a defective title, but himself and his brother can fight it out and then sort out their differences. That is what is called promissory estoppel. And suppose I deny the title of the landlord who has inducted me into the property by claiming that there are rival claimants as far as the property is concerned, I cannot question the notice which is given to me by the landlord. So that is 109, sir. Then another provision is there, 114 of the Transfer of Property Act. It says, suppose that the landlord receives the rent even after the termination of tenancy, does it amount to condonation or does it amount to waiver of notice? No, sir. It is taken without prejudice and without under protest and subject to the rights as far as a quit notice is concerned. These are all the various theory provisions as far as the Transfer of Property Act is concerned. And concisely, it is called contractual tenancy or contractual lease. Now we go into the ingredients of section 106, how a notice has to be given. Perhaps most of you know that the tenancy month varies from person to person. Normally the tenancy month is from 1st to the 31st of every month or 1st to the end of the month. Or as far as Telugu calendar is concerned, Amavasya to Amavasya. Amavasya to Amavasya, Telugu calendar lags behind English calendar by 15 days. And for example, that is Amavasya to Amavasya means last month, that is in July, the Amavasya came on 5th. Now in August, the Amavasya is coming on 4th. So it is from Amavasya to Amavasya means according to the Telugu calendar. Then the notice has to be given according to the Telugu calendar terminating the lease. Now we come to the section 106. A periodic lease can come to an end only by issuing a notice under the provisions of section 106 Transfer of Property Act. Notice is absolutely mandatory as far as contractual leases are concerned. Here, the Transfer of Property Act says 106 notice should be under what terms the tenancy has commenced, from what date to what are the documents executed by the tenant, for what purpose it is let out, what is the monthly rent, and how the rents have to be announced from time to time. Then what are the violations committed by the tenant, or the tenant has been irregular in payment of rents, or he has sublet the property, or he is creating acts of nuisance, or he has vacated but still hanging on to the premises. On these grounds, you'll have to state it clearly in the quit notice. And also, one important thing is to say the tenant, I hereby inform the tenant that if he continues in respect of the property after termination of the lease, he will be liable to pay a sum of rupees so and so towards damages and compensation in the form of mean profits at the rate of 40,000 rupees per month from the when the quit notice comes to an end. Then afterwards, I hereby call upon you to vacate and deliver possession of the leased out property within 15 days from the date of receipt of this notice, failing which my client will be constrained to institute legal proceedings against you, holding you liable for all costs and consequences incident thereto. But the Supreme Court has initiated this, how this has to be worded. I hereby call upon you to vacate and deliver vacant possession by so and so, or any date which according to you is the last date of monthly tenancy, and vacate and deliver possession, failing which I will be taking legal action and also claim mean profits from you at the rate of so and so. Please remember, transfer the suits under the Transfer of Property Act is very easy, but it's a very costly experiment also. Even if the quit notice falls short of even one day, your notice is irregular, notice is defective, the suit can be thrown out. That is the reason the Transfer of Property Act has now been amended somewhere in 2018 or 2019, whereby they say if you give 15 days time, itself is sufficient. When the tenancy commences, when it ends, it's immaterial. It's mostly tilted more towards the landlords. That's how the amendment has been brought about. And how the notice is, please remember, it's a very costly affair. Why I told you that is, when you pay court fee as far as the suit under the Transfer of Property Act is concerned, you value it under section 40 bracket 2 Court Fees Act. That means you have to value on the annual rent plus the advance which you have taken, that is the premium which you have taken to let out the property, and then pay court fee accordingly. And suppose your notice is defective and your suit is thrown out, what would happen is your client will lose all the court fees which he has paid. So be very, very careful when you draft the notice, because the notice is supposed to be the foundation as far as the future suit is going to be is concerned. Then, sir, normally if you see a lease deed, there will be a clause always, notwithstanding anything contained in this document, if the tenant commits a default for a continuous period of 3 months, he can be evicted without assigning any grounds. There is an exception clause which is normally provided to say that 3 months default is committed, you can automatically get rid of the tenant, irrespective of the period of tenancy. Then one more thing you must remember is any transfer any transaction covered by a lease for which reserves an annual rent, there the what is called is, it has to be properly stamped and it has to be properly registered. Then you can ask me one question, sir, what is the stamp duty which you pay in respect of a lease deed? As far as a lease deed is concerned, if it is within 3 years, you pay on the annual rent, you pay a stamp duty at the rate of 3%, 3% on the annual rent. And if it's more than 5 years and more than 5 years, you pay 5%. So please remember, why I'm trying to alert you on this is 17(1)(b) has been introduced by the Amending Act of 2001, whereby you say all transactions relating to delivery of possession, immovable property, etc., has to be in writing and has to be duly registered. And please remember, even if you give it for 1 month, your lease deed has to be registered. If you don't register it, it cannot be looked into for a primary purpose. Then what are the clauses you mentioned in the plaint? Same thing, sir. Your description of the parties and all. Suit for eviction, suit for ejectment, they call it ejectment, possession, and arrears of rent and mean profits. Then you say, I'm talking about the descriptive paragraph, brief facts. The petitioner, the plaintiff, don't say petitioner. Plaintiff is the absolute owner and possessor of house number so and so, measuring so and so square yards, with so many, with 1 + 2 floors, and the respondent and the defendant is a tenant on a monthly rent of rupees 10,000 or 15,000 per month, and subject to the terms and conditions of the lease deed dated so and so, executed by the parties. The lease deed is filed herewith and marked so and so. Next para is, the lease is from so and so period to so and so period, and the rent for every month is payable on or before 5th of every English calendar month. Next para you write, sir, is to say that the defendant is highly irregular in payment of rents and owes the plaintiff a sum of rupees so and so towards arrears of rent from so and so period to so and so period, and the defendant, in spite of several demands, has not paid the amount. And then you say, thereupon, the plaintiff, through his legal notice dated so and so, called upon the defendant to vacate and hand over possession of the leased premises. The defendant received the notice but did not send any reply. The office copy of the notice, along with the post acknowledgement, is filed and marked so and so. Next paragraph. You say that under clause number so and so, it is mentioned that notwithstanding anything to the contra, if the tenant commits a default of more than 3 months, he is liable to be evicted under due process of law. And also you say that the defendant is due and payable a sum of rupees so and so towards arrears of rent from so and so period to so and so period, which he has failed to do so, and hence he has contravened or violated the terms of the lease, and therefore the plaintiff is entitled for a relief of eviction and possession of the leased premises. Next para you say, sir, the suit scheduled property is located in a very vantage point, and the prevailing rents in the locality is rupees 30,000 to 40,000 rupees, And since the defendant has not vacated the premises in spite of the quit notice being given to him, he is liable to pay a sum of rupees 40,000 towards mean profits from the date of the expiry of the notice till the date of vacating the property. Then after that, you say cause of action for the suit arose on that is when you have inducted him into possession, and also on so and so date when the plaintiff through his legal notice called upon the defendant terminated the lease of the lessee and called upon him to vacate and deliver possession by so and so date. Next paragraph, this honorable court has jurisdiction to try this suit as the suit scheduled property is located at Regimental Bazaar, Secunderabad, within the jurisdiction of this court. Next paragraph is you say a court fee of rupees dash. I told you annual rent plus premium. You have to value it and pay it under section 40 clause 2 of the Court Fees Act. And next paragraph should be that no suit has been filed in respect of the same cause of action nor any suit is pending. Then after that, you say that the prayer clause, the plaintiff therefore prays for a judgment and decree for ejectment for so and so A for ejectment, possession of the suit scheduled property bearing number so and so by directing the defendant and all persons holding possession through or under him to vacate and deliver vacant possession to the plaintiff. B. To direct the defendant to pay a sum of rupees so and so towards arrears of rent from so and so period to so and so period and also so and so period. Then C1 is for proportionate mean profits from the date of termination, that is once the notice expires till the date when you file a suit of rupees so and so. Then future mean profits at 30,000 rupees from so and so to so and so. And then you say last one is for cost of the suit. Then the plaintiff signs and the counsel also signs, and you have also got the verification, and the verification is done at whichever place the suit is going to be filed. And then after that, whatever list of documents you are going to file, you will have to mention it as 1, 2, 3, 4, 5, 6, and then the plaintiff signs, and then you mention the schedule of property and give the proper description of the property along with the boundaries. And then the party also says the schedule mentioned above is true and correct, and then he signs. And then whichever place it is signed, you mention the place and the date on which it has been signed. And then you prepare the docket. This is how a plaint is drafted as far as a suit under the Transfer of Property Act is concerned. Please remember the CPC has been amended in 1976, whereby they have provided a new provision called Section 15A. Like the Rent Control Act, please remember sometimes what happens is the tenant keeps on prolonging the case. He does not pay the rent nor vacate the premises. Then in the 15A1, you can say the tenant is due so and so rent towards arrears from so and so period to so and so period. He has failed to pay the rents but still continue to occupy the property. He must be directed to pay the arrears of rent from so and so to so and also future rent. And in default thereof, all proceedings be stopped and eviction orders be passed, and I may be put in possession of the property. Then, in spite of the order passed under 15A1, the tenant does not pay, then you will have to file a petition under 15A2, not an execution petition, please. 15A2 to stop all further proceedings and strike off the defense of the defendant, and I request the court to put you into possession of the property. This is a new provision which you have to bear it in mind. That is 15A1 and 15A2. So this is as far as suits under the Transfer of Property Act, that is 105 to 114. But one thing you must remember is whenever you draft a notice that is going to be the foundation of your suit, be very, very careful in drafting it. Also inquire from your client when the tenancy starts, when it ends. If you give a defective notice, what will happen is your client will lose the court fee what he has paid and your suit is liable to be dismissed. So this is as far as the suits under the Transfer of Property Act is concerned, as far as eviction is concerned. So to recap, we have finished money suit, we have finished ordinary money suit, mortgage suit, then suit for specific performance, suit for accounts, and the rent control and the Transfer of Property Act cases. Today, and I think I've dealt with Partnership Act also, if I'm correct. Please clarify, sir, whether we have finished partnership suits. Yes, Mr. Prasad Rao. Have you?
Your interaction session?
No. Have you finished partnership suit, sir? If I have missed anything, please kindly remind me, sir, in the end. Then we go to pauper suits. Pauper suits. What is the provision under which pauper? Yes. What do you mean by pauper suits? Pauper suits means where a person does not have enough means, or he has means, or he does not have enough means to meet the obligation towards payment of court fee, or he has no means at all, he cannot pay the court fee immediately when he has to file the suit. Easy helpless. Law provides for such contingencies under Order 33, which says that Order 32 or 33, sir. It says that a person can file a suit as a pauper. Pauper means he can ask the court to give him permission to institute the suit without payment of court fee, at least for the present, at the time of institution. And whenever a pauper suit is filed, it is filed as an OP. OP means original petition. First and foremost is drafted almost like a plaint, but you call it as an OP, original petition. And under the provisions of Order 32 or Order 33 of the Civil Procedure Code, mention all the facts. And the court fee paragraph, you say that I'm filing the present suit as a pauper, as I do not have sufficient means to meet the obligation towards payment of court fee, or I do not have any means, any money at all to pay the court fees. I have got means, but I do not have sufficient means. And then you say, request the court to grant you permission to file the suit as a pauper. All proceedings under Section Order 32 or 33 is called suits filed in forma, IN space, forma, FORMA, pauperis, PAUPERIS, means that as a pauper. Then a notice goes to the government pleader, and notice goes to the opposite side, and then regular inquiry is conducted to inquire about the means of the plaintiff who has filed a pauper suit. And then if the court finds that this man has no means at all, or he has got means but no sufficient means to pay the court fee, court permits him to at least excuses him from paying the court fee at the threshold by saying that you can file a suit, but you have to pay the court fees later. Then the pauperism is allowed, or the court permits you to file a suit as a pauper. But when you file a pauper suit, all the ingredients you mentioned, but in the court fee paragraph you say that you do not have sufficient means to pay the court fee of rupees so under the relevant provisions of the Court Fees Act, and you may be permitted to file the suit as a pauper or in forma pauperis. Then when the notice goes to the government or notice goes to the other side and the government fights it tooth and nail and resists your pauperism request. But in case a court still on inquiry finds that you do not have means, court permits you to file the suit as a pauper and defers the payment of court fee to the end. And then once the pauperism is allowed, the OP gets converted into a suit. Then alone it is numbered as a suit. But suppose, let us say, after the pauperism suit has been filed, the plaintiff acquires some property. Please remember, the defendant does not give up easily. Defendant says, sir, he has acquired this property situated so this is a sale deed through which he has purchased. Even if the pauperism permission has been granted, if the person can be dispaupered. Dispaupered means he will be compelled to pay the court fee. And then once he pays the court fee, let us say steal, beg or borrow, he pays the court fee, then the suit will be numbered as OS. And whenever pauperism is allowed or disallowed, there's a right of appeal to go to the district court and question the orders of the lower court. Then how a plaint is drafted, sir? It is drafted as an OP. You state all the facts, but in the court fee paragraphs, you say that you do not have sufficient means to pay the court fee, or you have means but not sufficient means, or you do not have means at all. Then the court permits you to sue as a pauper. But here, one thing you must remember is, don't think that because court permits you to file as a pauper doesn't mean that you need not pay court fee at all. Ultimately, let us say on merits, suppose you succeed in the suit, the court fee which is awarded, or it is allowed, decreed with cost, let us say, then in that case, the court fee that is ordered will be collected by the collector from the defendant as arrears of land revenue. It will not, other cost you get, But as far as the court fee is concerned, the plaintiff will not be entitled to it. But in the schedule, when you say what are the means possessed by you, you say 4 bunions, 4 undergarments, then let us say so on and so forth. Or let us say you have what is called a hat, so on and so forth, which is worth so much. But I cannot pay such a heavy court fee. Then in that case, a person should not go without any remedy. That's the reason why the court grants you permission to sue as a pauper. That is as far as a pauper suit is concerned. Initially, it is numbered as OP, original petition. And once the pauper inquiry is conducted, and the government also cross-examines you, and the other side also cross-examines you, and suppose the court finds you have no means, it will exempt you from payment of court fee at the threshold. But once the suit is decreed, let us say, in case you succeed, the court fee which is awarded by the court will be recovered by the collector from the defendant towards their due as far as court fees is concerned. Please remember, the government does not leave you anywhere. The arms of the government is very, very long. They will always be keeping a close watch over the progress of the suit. Once they come to know that it has been decreed with cost, the cost, the first part of it is the court fee which is liable to be paid on the plaint will be recovered by the government as arrears of land revenue. That is as far as pauper suits are concerned. Then we go to injunction suits. Yes. So I think, please remember, please bear with me. I wanted to make this remark before we go to the interaction. There are about 30 plaints to be discussed, sir. If you want me to discuss all the plaints, I will discuss. If not, left to you. Because the question is, I don't want to leave it midway. Because I've dealt with about nearly 5 to 6 plaints till now. That is money suit, ordinary mortgage suit, specific performance suit, suit for accounts, rent control and TP Act matters, and then the pauper suits also. Tomorrow, in all probability, I'll be discussing the suits on injunction. Then different kinds of mortgages are there, how the suit is drafted. Then after that, we go to the suit for redemption, and then suit for foreclosure, and other things we'll discuss it later. Nearly there are about 30 documents, sir. If you want me to, 30 types of suits. If you want me to discuss every one of them, I will not leave it there because most of us are learners. Let us learn from the fundamentals. Let us know how a plaint is drafted. So now the question hour or interaction starts, please.
Sir, you can go ahead, sir. Niram Chandramurthy garu, please.
Excuse.
Sir, you can go ahead, sir. You can unmute yourself, sir.
Sir, this is Venkatesh, sir. Good evening, sir.
Good evening.
So, sir, hello?
Yes, please
under
go ahead. Please
under
go
the
ahead.
Rent Control Act, okay, it has to be filed under the Rent Control
Yes.
Court, right?
Yes.
Sir? It should not be filed under Civil Court.
No. Yes, is it clear, sir?
Sir?
Rent control cases are now almost on the wane, sir. Very rarely you find rent control cases now. Unfortunately, what has happened is, though the bill is ready, enhancing the rent to 10,000 rupees from 3,500, it has seen about 4 years. It is still not signed by the governor to become an act.
So, we will not be able to file under
I think
Civil
one of the candidates yesterday told me, sir, 3,500 is only peanuts. 3,500 today, you don't even get one room on rent. But today, the probable value, if you ask me, because I'm almost tenant oriented, it should be 20,000 rupees per month. That should be the 20,000 rupees should be the figure fixed, because cost of living has gone up, housing has gone up. You cannot get a rented premises less than 20,000. I think to the best of my knowledge, 15,000 is the rent now prevailing, even for a one-bedroom flat.
So, even then, okay, we need to file under Rent Control Act
Provided it's less than 3,500 rupees and not more than 15 years of construction.
if it is more than that, then it has
Then
to
you have
be
to go
under
by a civil suit only. That's under 106, Transfer of Property Act.
Thank you, sir.
You're welcome.
Sriramurthy garu.
Sir,
Yes,
sir, I am the owner of the old building, sir.
Yeah.
Around 50 years.
Yeah.
My tenant is still continuing. I want for to dismantle that building as it is old building. So, what is the remedy available for me?
What is the rent, sir?
Rent is above 10,000, sir.
Rent is 10,000. You'll have to go by a civil court, but civil court you don't have any remedy, sir. Only thing is you give a notice to the municipality that it's in a dangerous condition. Ask the municipality or the corporation to demolish it.
Okay.
That's the only remedy.
So, that is the only remedy, sir.
Or else you give a notice saying that the premises is in a dilapidated condition, is in a dangerous condition.
Okay.
Please vacate and deliver vacant position. But if you come under the Rent Control Act, you come under Section 12, you will have to give an undertaking that you let it out to the same tenant on agreed terms of tenancy. Sir.
Achha, sir.
Yeah.
Okay, sir. Okay, thank you.
Yes.
Anybody else?
Sir.
Yes. Please go ahead.
Sir.
Yes, sir.
In the declaration of title shoot, it was filed in the year of 2012, sir.
Right.
The plaintiff transferred the part of the shoot schedule property to her sons, two sons.
Right.
In 2017,
yes,
after filing of the suit, after 5 years after filing of the suit, sir,
right,
the defendants side, they did not file any implead petition.
Right.
So, is there any limitation to file the implead petition regarding this one?
As far as impleading petition, there is no limitation at all, sir.
Already they have the knowledge.
Even if they have knowledge, you can also file a petition and order 1 Rule 10(2) to make them parties, make them as parties.
No, ourselves, how we can
no, as a plaintiff, you can do it. You can say that you have come to know that sons have succeeded to that property, and by whichever document or whatever it is, and I want a decree which is binding on all the people. That's the reason I want them to be made part. They are proper and necessary parties, not on the date of suit, but subsequent developments or the subsequent events can always be brought to the notice of the court.
If on behalf of the plaintiff, if you want to file that implead petition, is there any mistake in our side?
There is no mistake at all, sir. You have come to know about 2012 is the date when you have come into possession. 2017 is this development, which you have come to know about it now. So to get a concrete decree, you will have to implead them, sir. Under Order 1, Rule 10, Bracket 2.
Okay.
You need not wait for them to get impleaded.
Okay. Thank you, sir.
Yes. Next, please.
Sir, good evening, sir.
Good evening, Nokia. Jamuna Tiwari.
Sir, section 22, sir.
22 of the Rent Control Act.
Yes, sir.
The Rent Control Act is, suppose in the eviction case you lose as a tenant, or as a landlord you lose. Let us put it that way. Then you file an appeal before the Small Causes Court if you are in Hyderabad, and if you are in the Mumbai district area like Rangareddy where you are practicing, you file a rent appeal before the principal senior civil judge, who is the authority under the Rent Control Act as far as the district is concerned. And then suppose you lose in the appeal also, then whatever grounds you allege where you are aggrieved by the appellate court judgment or the lower court judgment, you can file a revision before the High Court, what is called a civil revision petition under Section 22 of the Rent Control Act. Are you able to understand, please?
Yes, sir. Sir, one more, sir, Section 10.
Section 10 of what? Section 10 is what is called in the Rent Control Act. There are various grounds mentioned, sir. Mentioned, madam. One is default, another is subletting, another is self-occupation for residence, another is self-occupation for bona fide starting a business, additional accommodation when the accommodation is not sufficient. When you have got various buildings, but this building is more suitable to you, then you have got what is called acts of nuisance, or the tenant has vacated but is ceased to occupy for a continuous period of 4 months, or is creating acts of nuisance. All these grounds are enumerated in Section 10 of the Rent Control Act, and that is why it is called statutory tenancy. Unless you satisfy any of the requirements mentioned in section 10, you cannot get rid of a tenant. Are you able to understand, please?
Yes, sir. Thank you, sir.
Any more questions?
సార్ నమస్తే.
నమస్తే
సార్ నమస్కారం సార్.
చెప్పండి సార్.
ఇది ఈ కొత్తపేటలో ఒక ప్రిన్సెస్ సార్, వన్ ఆఫ్ ది కాంప్లెక్స్ ఫస్ట్ ఫ్లోర్ 10 years నుండి టెనెంట్స్ ఉంటున్నారు. అయితే అతి టెనెన్సీని వితౌట్ కన్సెంట్ వేరే వాళ్ళకు ఆ ఓనర్ అమ్మేసుకున్నాడు. ఆ కొన్నటువంటి వ్యక్తి దౌర్జన్యంగా వీళ్ళని వెకెట్ చేపిస్తే దాని మీద ఒకటి పర్పస్ ఇంజక్షన్ ఆర్డర్ షూట్ వేసాను సార్ నేను. బట్ దాని అది పోలీసు వాళ్ళు కూడా వాళ్ళకి రెంట్ రెంటర్కే అది ఇతనికి కొన్నతనికే సపోర్ట్ చేశారు.
యూజువల్ సార్.
ఇది వాంటల్లి వచ్చి జనరల్ గా లాక్ పలుకొట్టి మొత్తం సామాన్ అంతా బయటపడేసి అప్పే చేస్తున్నారు.
సార్, నౌ
వాట్ ఈస్ ది రెమెడీ?
cheaper remedy provided to you is under section 6 and 7 of the specific fact. You can ask for repossession of the property and file a summary suit under 6 and 7. You mentioned that you are in possession, you are irregular in payment of rent, you have followed all the terms of tenancy, and you have been dispossessed wrongly on so and so date, and please direct the court, ask the court to put you back into possession. That is under section 6 and 7 of the specific fact. ఎవరు మాట్లాడుతున్నారు?
సార్ వన్ బై వన్ అడగండి, ఓవర్ ల్యాప్ అవుతుంది.
అదేమన్నాడు తెలుసా,
చాలా డిస్టర్బెన్స్ అవుతుంది.
నాగచంద్రం గారు, you can file a suit under section 6 and 7 of the specific fact within 6 months from the date of dispossession, and saying that you are in possession earlier and you have been dispossessed in not by process of law but by illegal means. You can ask the court to put you back into possession by filing a summary suit under section 6 and 7 of the specific fact within 6 months from the date of dispossession. Are you able to follow, sir? Yes, next.
Sir, good evening.
Good evening.
I'm Satya.
Yes, sir. Yes, sir.
Sir. So my submission is that, sir, regarding to this Order 6 Rule 15(4), sir.
Yeah, verification affidavit.
So majority of the cases, the either it may be the plaint or the written statement, they are not filing these affidavits.
Written statement, it is not filed, sir. It is only filed along with the plaint. It is absolutely mandatory. You cannot dispense with that. If not, your suit cannot be numbered.
So in spite of that also, the judges are not numbering.
If it is there, you just file a petition for rejection of the plaint. So
Okay,
that
thank you, sir.
mandatory under Order 7, Rule 10.
But regarding to WS, sir?
WS, there is nothing, sir. WS, no one files Order 6, Rule 15.
So, but as per this amendment, 1999 amendment, every plaint, this is that pleadings must be supported by, pleadings include WS also, sir.
Sir, 99 Act was a stillborn child, sir. It was almost repeat.
Oh, so okay. Thank you, sir. Thank you, sir.
Mr. Prashant. Mr. Prashant. Mr. Prashant, are you there? Prashant గారు క్వశ్చన్ అడిగారు సార్ ఇక్కడ.
చెప్పండి.
Sir, if any unregistered documents exhibit mark చేయాలి అంటే what to do?
Unregistered document cannot be marked as an exhibit, sir. The court can raise an objection at that time. But if you allow it to be marked, later on you cannot question it. But there is a provision under Order 13, Rule 3, CPC. You can ask the document to be demarked if it has been marked by mistake.
Any more questions? Can we conclude the class for today?
Sir, one more question is there, sir.
చెప్పండి దేవారి గారు.
Sir, TP Act section 40 class 2.
It is not TP Act, it's Court Fees Act.
Sir, అదే
Court Fees Act లో మీరు TP Act suit వేస్తే you'll have to value it at the annual rental value plus the advance what you have taken. That should be the consolidated amount on which you have to pay the court fee.
సరే అది కొంచెం డీటెయిల్ గా ఎక్స్ప్లెయిన్ చేస్తారా? నాకు అర్థం కాలేదు.
లేదమ్మా, ఇప్పుడు సపోజ్ యూ ఫైల్ a suit under the Transfer of Property Act, then when you pay the court fee paragraph mention చేసేటప్పుడు what suppose 10,000 is the rent, 10,000 into 12 will be 1,20,000 plus suppose you have received 1 lakh as advance, 1,20,000 plus 1 lakh will be 2,20,000. So you pay the court fee on 1 lakh 2,20,000. That will be the value as far as 42 is concerned.
Oh, sir, thank you, sir. Thank you, sir.
Sir, one doubt, sir.
Yeah.
According to lease, normally the lease deed will be executed on 100 rupees stamp paper, sir. It will not be registered most of the cases.
Yes.
With regarding that aspect, can we file a suit basing on the 100 rupees stamp paper with regarding to default?
Sir, as far as one judgment of our High Court is Justice Sanjay Kumar, when he was in our High Court, he said at the threshold the question of court fee cannot be gone into. If they want, the court can frame an issue and collect the court fee from the party.
Sir,
issue can be framed and court fee can be collected later also.
Okay, sir. So we can file it.
You can file it, but one thing, objection will be raised at the time of marking it.
Exactly. Deficiency of stamp duty.
Exactly, sir. Or you can get it validated also if you want.
Okay, sir.
But does not absolve you from registration, because 17(1)B, all documents will have to be registered.
Yes, sir. Somebody previously says that if lease is above 1 year, then only it should be registered.
No, sir, that has gone now. And it reserves an annual rent. But now, after 17(1)B has come, even if it's 1 month, it should be registered. It should be on a proper stamp.
That is what, after listening to you only, that I confirm, sir. Thank you.
That's what I told you. Devudu Varamichina Pujari Addu, government comes in the way everywhere. And sir, even if the government does not come, the courts collect the stamp duty.
Second person.
Yeah.
Thank you.
Can we conclude the day? Thank you. As of now, we have concluded the day for today. Any questions we ask? We see you tomorrow again. Thank you.